everybody, and welcome to another episode of LJ Law, Family Law TV. I am Bonnie Leonardo, your host. Today's question comes to us from Jason, and he wants to know if the house that was purchased during the marriage is his separate property because him and his wife signed a quitclaim deed. Before I get started answering that question, I want to remind you that if you have questions about this topic or any other family law topic, do not hesitate. Go to vegasdivorcemeeting.com. I'll be more than happy to sit down with you to discuss your particular situation. So Jason is in the process of getting a divorce. He comes to me and states that they have no joint bank accounts, and the only thing that they have together is a home that they purchased during the marriage. However, the wife signed over a quitclaim deed recently to him. He wants to know if the house belongs to him and him only, and it will be considered his separate property, and does he have to share any of the equity to the house? The answer to this question, as I explained to Jason, is that this is a very misunderstood area of law. Nevada is a community property state, and therefore anything that is acquired during the marriage, whether it's assets as a home or debts as credit cards, is considered community property, and upon a divorce, the judges will begin by attempting to divide these assets and debts evenly. The matter of the house having a quitclaim deed signed from one spouse to the other is a point of contention in many divorces. The courts will look at a quitclaim deed to see whether or not the intentions of the party were really truly to give that interest to the other party. Oftentimes, the courts will not look at a quitclaim deed as an intention of one party to give up the right to the property to the other parent, to the other spouse. And so therefore, it depends on the case. It depends on whether or not there was a prenuptial agreement, whether there was a post-nuptial agreement, what the parties' intentions really were. We have to look at that through the facts of the case. But I can tell you that many times a quitclaim deed that is signed over from one spouse to the other, given that one spouse the right to the property, is oftentimes not looked at favorably by the court or granted by the court. The court does look at the fact that Nevada is a community property state, and therefore anything obtained during the marriage will be subject to equitable division. So I hope this answers your question, Jason. If you want to talk to me about this a little bit further, go to vegasdivorcemeeting.com. If you like the video, please hit the like button. And if you know somebody who can benefit from this information, please don't hesitate and share it with them. And as always, I want to thank you for tuning in, and I will see you next time.